group insolvency, and also several other amendments which have been discussed in the recent past. The use of prepackaged insolvency resolution process for MSMEs is also expected to gain traction in near future. There are many other asks of the MSMEs that may also, come see the light of the day. Also very privileged to, we are awaiting Dr. Mukulita Vijayvargiya to also join in, as an expert. She's a great expert on the subject, and we do look forward to hearing from her the perspective on further enhancing the efficiency of resolution process of stressed assets. May I also welcome Mr. Swaminathan, Managing Director, State Bank of India. Also, Mr. Shardul Shroff, Executive Chairman, Shardul Amarchand Mangaldas, and also our Senior Vice President, Mr. Shubhrakant Panda, who is with us today. And I request him to kindly throw some spotlight on the achievements of IBC and share his perspective on the insolvency regime in the country. So may I, with these words, request our Senior Vice President, Mr. Shubhrakant Panda, to share his welcome address, please. Over to you, Mr. Panda.
Thank you, Jyoti. Dr. Mukulita Vijayvargiya, full-time member IBBI. I know we're waiting for her to join in. Mr. Rajesh Kumar Gupta, CGM, IBBI. Mr. Swaminathan, Managing Director, Risk Compliance and Stressed Assets Resolution Group, SBI. Mr. Shardul Shroff, Chairman FICCI, National Committee on Stressed Assets, and Executive Chairman, Shardul Amarchand Mangaldas & Co. Distinguished guests, ladies and gentlemen. At the outset, I would like to extend a warm welcome to all of you and acknowledge the presence of senior officials of IBBI who have been deeply engaged in ensuring that the organization is responsive and geared towards successful implementation of IBC in India. The Insolvency and Bankruptcy Code is indeed a landmark reform and has won plaudits, including a specific mention from the World Bank, which in its 2018-19 report cited IBC implementation as a major factor in India's improved ease of doing business ranking. The resolution of non-performing assets has been a subject of much discussion, and I would say rightly so, as the twin balance sheet problem at one point in time looked to overwhelm the banking sector. However, a slew of corrective measures, not least the adoption of IBC, has helped in turning things around. In fact, it is a tribute to the solidity of the Indian banking sector and the far-sightedness of policymakers and regulators that the pandemic period has not resulted in a major crisis per se. As per the RBI financial stability reports, there has been a substantial decline in gross NPA ratio of scheduled commercial banks in India from 11.5% in FY18 to 7.5% in FY21. Also, apart from facilitating recovery of NPAs by banks, the code has resulted in resolution plans for 348 corporate debtors up to March 2021. The IBC regime promotes efficiency in credit markets as well as entrepreneurship while optimizing valuation of assets. Foreign investors too are seeing this as an opportunity to enter the Indian market. And moreover, a highlight has been the continuous feedback mechanism to take inputs from stakeholders. FICCI has been privileged to participate in several such consultations such as today, and we appreciate the opportunity to engage with all of you and give our views which have been collated from our members comprising of experts like Mr. Shroff and others. Let me now turn to some suggestions which we feel are important to further improve the efficacy of the IBC regime. Firstly, I would like to reiterate the importance of strictly adhering to timelines. This is absolutely critical for the success of the insolvency regime, as delays in admission and or completion of the resolution process leads not just to erosion in the asset value, but many a times reluctance on part of the bidders to participate in the process. Next, with the current demand for stressed assets ebbing due to uncertainties associated with the pandemic, existing restrictions on buyers of stressed assets should be rationalized. A diligent review must of course be done to ensure that any entity participating in CIRP has neither defaulted on its own dues nor caused any related entity to default. But having said that, otherwise debarring group entities from participating is counterproductive and more often than not detracts from best possible outcomes. Next, All authorities should be explicitly debarred from raising further demands on the corporate debtor for the prior period once the resolution plan has attained finality. I think this is a key cornerstone of the IBC code and must be strictly adhered to. Finally, the litigation infrastructure of NCLT needs to be strengthened through capacity building measures such as allocation of more resources to the existing benches, filling up of vacancies and establishing additional benches, and introducing specialized benches exclusively for IBC matters. It is also desirable to continue with digital board of hearings going forward to lend efficiency to the functioning of NCLT. In conclusion, it is fair to say that IBC has delivered on the challenging task of strengthening the insolvency regime in India. Not only has it been able to address the issue of sticky NPAs, but IBC has also been effective in improving credit discipline, creating foreign investment opportunities, and most importantly, saving livelihoods by preventing companies from going into liquidation. And for this, we definitely must thank IBBI for being a pivotal part of this process. Thank you for your kind attention, ladies and gentlemen. And let me end by reiterating on behalf of FICCI that we look forward to more such interactions. Thank you.
Thank you, sir. I now invite Mr. Shardul Shroff, Executive Chairman Shardul Amarchand Mangaldas, to deliver the theme address. Mr. Shroff is also Chairman of FICCI's Stressed Asset Committee and has been leading FICCI's initiatives in this space. And FICCI is privileged to have his constant guidance. Over to you, Mr. Shroff.
Thank you, Jyoti and Abha. Dr. Mukilita, Dr. Subrakant Panda, Mr. Swaminathan, Mr. Rajesh Kumar Gupta, distinguished guests and friends. Good morning to all of you, and thank you for having me today to speak on the issue of the 5 years experience of the working of the IBC and the future as it will unravel in relation to how the Act can be strengthened and the processes made seamless with other laws. I feel the best way to trace the journey over the last 5 years is to think of the direction that the legislative activity and the jurisprudential development took place during this time. Looking back, I think we can divide the IBC evolution into 3 distinct but partly overlapping phases. The first phase of the IBC related to testing if the IBC can be taken on the road at all. That is, whether the IBC is workable and is constitutionally valid. The first was checked by the Supreme Court in that IBC has been recognized as a single point resolution mechanism for companies in what was previously an extremely fragmented insolvency landscape with various state and central laws dealing with insolvency and relief measures. This came up before the Supreme Court in the case of Innovative Industries versus ICICI Bank in 2018, in which case the Supreme Court held that the IBC forms a code complete in itself and is exhaustive on the matters dealt with therein, and held that it would prevail over the repugnant state legislation such as the Maharashtra Relief Undertakings Special Provisions Act of 1958, or else it will be hindered and obstructed in such a manner that it will not be possible to go ahead with the insolvency resolution process outlined in the code. The second phase was testing the scheme of IBC as constitutionally valid, and this was dealt with in the Swiss Ribbons case in 2019, in which the Supreme Court held that the provisions of IBC pertaining to initiation of corporate insolvency process, voting in the committee of creditors, distribution in liquidation, withdrawal of the corporate insolvency resolution process, disqualification from submitting a resolution plan, information utilities, and the powers of the resolution professional were all constitutionally valid. This judicial development was aided by preliminary amendments in the code in 2017 and 18 to make the law workable and close loopholes that were arising in implementation. The second phase of IBC also related to testing how it could drive, once on the road, whether the resolution's own process could actually result in value maximizing insolvency resolution. Outside of the IBC, we saw greater amounts of settlement occurring, indicating that IBC was rebalancing the creditor-debtor dynamic. The whole system and ethic in relation to overdues was changing, and customers and debtors were voluntarily paying up to the banks especially when they were faced with the situation of losing control over their own companies. Within the IBC, we started seeing resolution in big matters such as SR Steel in 1919-20, where the lenders received much higher payouts than would have been possible prior to IBC. These cases also resulted in settling complex, debated issues such as the importance of outcomes under the IBC and the manner in which gains from these outcomes would have to be allocated between different stakeholders of the insolvency process. At the same time, cases such as K. Shashidhar versus Union of India, decided in 2019, settled that the Committee of Creditors would have control over the commercial aspects of the insolvency resolution process, and that the adjudicating authority's role would be limited to checking for legal compliance of the provisions of the code. This judicial development was aided by amendments made in 2019 to the code and a slew of changes in the regulations which underlined and clarified these principles. The third phase of IBC, in which I believe we are now, relates to the checking of how IBC traverses different types of roads and maneuvers around other cars on the road, how the IBC works within the constraint of the changing economy, and how it interacts with other legislation. In the last 2 years, a large number of cases on IBC's ability to coexist with other legislation have come to the fore. Section 32A, whose validity has been upheld by the Supreme Court in Manish Kumar versus Union of India, was enacted to deal with completing considerations of enforcement legislation such as the PMLA and the IBC. Similarly, cases dealing with the binding effect of the IBC on government creditors has come to the forefront and resulted in the Supreme Court once again clarifying in Ghanshyam Misra versus EARC in 2021 that the clean slate principle will prevent past statutory liabilities or legal proceedings in relation to them from being re-agitated or raised after the approval of the resolution plan. However, the on-ground implementation of this position of law remains a challenge, as does reluctance of different government agencies to continue and renew licenses for resolved debtors. These two are huge problems even now in relation to implementation of finally determined resolution plans. We have also seen that the IBC works very well in situations when there are various competing resolution applicants where the microeconomic situation is not conducive to competing resolution plans. The IBC may not work as well as a free competitive economy does. This is why the IBC was suspended in the wake of COVID-19 and precisely why the government introduced pre-packs for MSME, which allow a more limited competition with promoter plans. However, this challenge remains live for other resolution applicants. The third phase has shown that IBC's own framework, will only be able to work well when it has enough fuel to run the road. We need to only measure that the NCLT is running at capacity, but upgrading capacity by increasing the number of judges and ensuring that they have all relevant technological, administrative, and research support to dispose of IBC cases at speed and in a manner that prevents unnecessary litigation is required. Thus, in my view, the next phase of the IBC development ought to focus on making the IBC an all-weather legislation and to ensure that its interaction with other legislation is seamless. What are the directions that the IBC is expected to take, and what kind of budgetary changes and may be anticipated? The government has clearly indicated that it would like to see the provisions of the cross-border insolvency and the provision of group insolvencies recognized in an amended IBC. Even currently, the law has been interpreted and applied in a manner that group insolvency and cross-border insolvency are dealt with, especially in the case of Jet Airways and in the case of Videocon. More complex group insolvencies are also being considered. One of the major moves that took place in the third phase related to the introduction of the IBC to financial companies, where extreme distress had been seen in relation to large companies such as DHFL, and now in the case of SRE and SRE Finance and SRE Housing Capital. So these are perhaps the latest cross-border, legislation, interpretations and application of the law, where the Reserve Bank of India has also had a great hand in trying to resolve matters and to provide for solvency and resolution even in non-bank finance companies. The 3 or 4 issues which have been addressing the mind of the Ministry of Corporate Affairs and perhaps even the IBBI relate to the existing SWIFT admission program, and a recent questionnaire had been sent out on asking for suggestions in relation to how the process of admission and the reliance on the IU undertakings for the purpose of determining the value of the default or the claim were called for. The time period for approval of resolution plans and the outlook that one should have, especially in the light of the 32nd report of the Standing Committee of Finance on implementation of insolvency and bankruptcy, pitfalls and solutions of August 2021, the preparation of a code of conduct for creditors, the issue in relation to the procedural delays and how these could be shortened and speeded up, the issue in relation to the insolvency, the voluntary insolvency liquidation processes and the termination thereof or the closure thereof, and lastly, the preparation of an IBC fund. All these may also find their place in a new amendment which may come as early as the budget session of the Parliament. With these words, I now hand it back to Jyoti and Abha to take the session forward.
Thank you, sir, for your insights. At this juncture, may I acknowledge the presence of Dr. Mukulita Vijayvargiya, whole-time member IBBI, and welcome her to the forum. We apologize, ma'am, we had to start the proceedings without you. I hope you can hear us. I think she's still having problems, but
yeah, she's there.
I can see you. Yes. Okay. So moving on, I now invite Mr. Swaminathan, Managing Director, Risk, Compliance and Stressed Assets Resolution Group, State Bank of India, to deliver the special address. Banks are a key stakeholder of the ecosystem, and we look forward to hearing the perspective of country's largest bank on making the resolution process more effective. Mr. Swaminathan, please.
Thank you, Abha, for the introduction. Senior Vice President FICCI, Sri Shubhakant Panda, Chairman FICCI National Committee on Trust Asset, Sri Shradul Sharaf, full-time members IBBI, Dr. Mukulita and Mr. Shutakar Shukla, CGM IBBI, Sri Rajesh Kumar Gupta, and other office bearers and members of FICCI and IBBI and other distinguished guests and my fellow panelists. Good morning to you all. At the outset, I would like to thank Ms. Jyoti from FICCI for her kind invite to speak in this special conclave. My compliments to FICCI for their stellar work as the industry's voice for policy change. While on the conference theme of 5 years of IBC, like the speakers before me mentioned, I have no doubt in acknowledging that it has been a legislation that has brought significant changes in the way corporate stress is resolved in this country. I'm sure all of you would agree that IBC has made a significant contribution in strengthening the resolution framework. The advent of IBC in 2016 brought in a mechanism for an orderly resolution of businesses that have gone into stress. I must congratulate IBBI for their pioneering work in promoting and implementing IBC in a way that it has become the preferred resolution mechanism. I also would like to place on record the immense contribution of the government and the parliament in making required amendments in the law from time to time to remove impediments in its implementation. Credit also goes to various tribunals and Honorable Supreme Court for upholding the law in the face of numerous litigations challenging validity of the code as well as interpretations of the provisions there. But I must also confess that it could have been better. But there is no denying the fact that this process in the last 5 years has produced far better results than what the earlier hard recovery measures managed to achieve in the previous years. Also, in my view, 5 years is too short a period in history for an enactment like IBC to be judged. Be that as it may, coming to my assigned topic for the day, a perspective on efficient resolution of stressed assets and making IBC more effective. I would like to share a few thoughts, and some of them have been echoed by my previous speakers, so pardon me for some repetition. The biggest challenge that we face today, as all of us know, is the absence of a time-bound resolution as envisioned by IBC. There can be multiple actors and factors contributing to these delays, and we will see a few of them one by one. To start with, it is not uncommon that the entire process would move in a time bomb. As mentioned, the Ministry of Corporate Affairs have circulated a paper seeking public comments on proposed amendments in the code to remove delays at the stage of admission of CIRP, as well as at the time of approval of resolution plans. Recommendations such as making certificate of default issued by an information utility as sufficient ground for proof of default for admission, fixing 30 days timeline for approval of resolution plan by the adjudicating authority, etc., are some excellent proposals, and I hope will address most of our concerns. And to address the problem is also to augment their capacity, increase the number of benches, as mentioned by my previous speaker, and stop them as well adequately. Second is that tribunals should discourage frivolous petitions that are often brought in by unscrupulous promoters. Some borrowers, albeit unsuccessfully, prefer to exhaust all judicial options to frustrate timely resolution. The judicial forums should be able to see through such design and ensure that precious time is not wasted. Another area is ability of RPs and NCLTs to ensure that successful resolution applicants implement the approved plans in a time-bound manner. Here again, we have seen a few cases where the SRAs bring in specious arguments and delay the implementation. All these delays together cost money and seriously impact timely recovery for banks. Next thing where a lot more efficiency can come in is the way in which the COCs function. It would be necessary that there is a fairly senior level representation in COC to facilitate meaningful discussions as well as faster decision making. Skill building for COC members and IPs through webinars and in-person training programs at bank level as well as ecosystem level involving IBBI, IIIPI, IBA, etc. have been very helpful. And I'm sure that this conference is also one such effort in that direction. It is also important for COCs to be consistent and follow the due process and back up all their actions with proper documentation. I'm saying this because non-adherence to certain processes or resorting to shortcuts gives room to further litigations, which results in avoidable delay and at times a complete failure. The next important stakeholder in the process is a resolution professional and his or her relationship with the COC. I would like to reiterate that the relationship between COC and RP has to be very constructive. Because the shared goal of COC and RP is an orderly resolution and maximizing the value for all stakeholders. That can be achieved if only there is a healthy, harmonious, and a professional relationship between COC and RP. And this also requires superior skill sets and professionalism to be displayed by the RPs. Shifting gears, last year India adopted a pre-pack insolvency regime for small defaults under MSME category. This was hailed as a major initiative as this could help resolve stress in MSMEs who may not be fit enough to be tried under the regulatory act. This also brought in a unique feature of debtor in possession approach that could be very helpful to such stressed enterprises that are small. We have not seen many MSME borrowers approaching banks for a pre-pack resolution. In my view, such reluctance may be due to apprehensions in the minds of such borrowers that in case of COC deciding to convert the PIRP into CIRP, they may lose control of their businesses. Further, some of these borrowers may not be sure whether they will come clean under the transaction or it may be just ignorance. My suggestion to industry bodies and IBBI is that we should work towards popularizing the pre-pack. A few successful resolutions would help build up a positive outcome. That will also help enhance the coverage of units that are eligible to be covered under pre-pack by further amendments to the code. Given the disproportionate impact of COVID-19 on MSMEs, this may be the right time to pursue a greater adoption of pre-pack. I request the insolvency professionals to pursue this as a specialization. We will be helping in preservation of several stressed enterprises and protect employment that they offer. The next I would like to mention is the group insolvency. It's an area of IBC where resolutions are getting delayed due to lack of adequate provisions in the code and lack of clarity in certain interpretations. It assumes significance as many of the failed enterprises in our country, as we know, have created a web of connected corporates with whom they enter into questionable transactions. And it is important that such corporates are resolved adopting a group approach. Since the working group on group insolvency has already submitted its report, it's time for taking a closer look at these recommendations and make amendments to the code to facilitate faster and systematic group insolvencies. Another area that needs further evolution is the cross-border insolvency. The country is poised to adopt a cross-border insolvency regime very soon. The government intends to bring amendments to add cross-border insolvency provisions in the code along the lines of ancestral model. So this is a third generation reform, and I believe will be a huge step forward in making IBC truly an international law and enabling scope for closer interactions amongst the IBBI, the insolvency professionals, and insolvency lawyers with their international counterparts. In pursuit of individual insolvency, the government had notified provisions of the code, the rules and regulations pertaining to insolvency of personal guarantors in December 2019. Since then, many cases of individual insolvency have been filed by the financial creditors, but very few have been admitted so far, and no case has been concluded to the best of our knowledge. One of the reasons may be lack of capacity and preoccupation of NCLTs with the regular IBC and company law cases. To resolve such matters in a time-bound manner, I suggest setting up more NCLT benches and also capacity building of NCLT members in this area. Finally, I think one of the significant but underappreciated contribution of IBC is the definition and actions in respect of avoidance transactions. However, on ground, nothing much has happened on account of inability of RPs to take such claims to its logical conclusion. It is also impacted by certain judicial pronouncements, which has led to uncertainty in this. Many promoters, as we know, indulge in questionable transactions, mostly among related parties, and manage to siphon off substantial funds prior to commencement of insolvency process. Hence, there is an urgent need to clarify the provisions of the code in respect of such transactions and their continuity even post-resolution to be pursued. While concluding, I wish to once again thank Vicky for this opportunity and thank my fellow panelists. I also wish each one of you a great year ahead. Jai. Thank you. Over to you.
Thank you, sir, for sharing your views. It is now our pleasure to invite Dr. Mukulita Vijayvargiya, whole-time member IBBI, to deliver the inaugural address. Ma'am has more than 40 years of experience in legal fields in various capacities. She has served as an advocate, law teacher, researcher, guide to PhD scholars, law officer, civil servant as a member of the Indian Legal Service, and legislative draftsperson. Prior to joining IBBI, Ma'am served as Additional Secretary in the Ministry of Law and Justice, Government of India. I now request Dr. Vijayvargiya ji to share her vision with us. Over to you, ma'am.
Thank you, Jyoti ji. I thank FICCI for organizing the seminar, especially on countries celebrating Amrit Mahotsav, Amrit Mahotsav for independence. And especially this has been also organized when we have completed 5 years of the enactment of the IBC also. My season's greetings to all. I thank Subrakanta Pandaji and Swaminathanji and Shadu Shravji for sharing their views and their expectations regarding IBBI and IBC both and the processes.
Ma'am, we are not able to hear you. We can see you.
Not now or from the very beginning?
Now, yes, no, just maybe 1 minute.
Now, am I audible?
Yeah. Yes, ma'am, you're audible.
सभी भाई बहनों को मेरा नमस्कार. Now, these 5 years of IBC, that's the theme. 5 years of IBC have been very challenging, very adventurous, because the process envisaged under IBC, it has that process. It was a paradigm. It's also now also a paradigm shift.
We are not able to hear you again.
Am I audible?
Yeah, now, yes.
So this regime provided for a new insolvency regime. It provided for a resolution process which is time bound, and it infused technology with the professional expertise with the minimum judicial intervention and supervision. Market problems had to be solved with the assistance of the market people. And every default or fault should not be treated as a base for litigation. I think that is the main intention of the enactment of this code also. Now we see that generally whenever any statute is enacted, it generates number of litigations. We don't have the practice that for every enactment, we should have judicial impact assessment. If that is the process, certainly I think we will be able to draft the law in a better manner, or capturing all those situations where it should not litigate, or with least imperfection as far as the litigation generation is considered. But we know that this code, which was enacted with a paradigm shift, no doubt it created an ecosystem. I think it was for the first time in the country that ecosystem with a sound technology, ever evolving technology is there. And every law which is enacted, the main purpose is that it should conform to the Constitution, to seek to its citizens justice, social and economic, liberty of thoughts, expression, belief, and worship, equality of status and opportunity, and fraternity, for assuring dignity to the individual and of the country also. These objectives can't be achieved unless the governance structure of the country, maybe of the country or the corporates, it provides for establishing a transparent and accountable regime that we elect. And we started these objectives, I think, after the liberalizing policy of 1990s. After 1990s, I think we have started, and in every law we are providing for such a mechanism process that transparency and accountability is very essential for good governance, maybe of the country or the corporate. Now, for establishing transparency and accountability, certainly we have technology before us nowadays. And in this under this very code also, we have provided for information technology. Through manner of technology, certainly judicial time can be shortened or cut, or judicial time will not be wasted, because there is a technological driven process for producing authentic record of default, so that no time is wasted for just determining whether there is a default, how much is the default. So if this can be achieved through technology, certainly courts will satisfy, or the judiciary will satisfy and determine that issue, I think, speedily, without wasting their time, and we can address the challenges of the market. For establishing transparency and accountability also, we should have professionals, because professionals who are having domain knowledge in that area or the subject matter, certainly that fellow can handle the subject matter or any issue before it, or any matter regarding resolution also in a seamless manner. Maybe he knows about the compliance. What happens? Sometimes delay, maybe in the court, you will find that you have to file counter, you have to file rejoinder, then you have to engage lawyers, and then certainly when you engage lawyers, then he will say that, okay, we will do next week, we'll sit next week. So time is, time is taken and the matter is delayed. And that's why this code provided for professionals and experts who can handle, who can carry further the process outside the court with minimum judicial intervention. Because now we all know that the commercial wisdom of the COC cannot be reviewed by the judiciary unless there are material particulars on something basic has gone wrong there. It is not that judicial review is not there. Judicial review is a part of the basic structure of the Constitution. But generally, this should not be intervened by the judiciary, especially adjudicating authority and CLT. Now, when we have established the process of professionals, when we establish the process of this technology, certainly accountability can be fixed either through the statute or through a culture. Now, the time has come in India that we have a legal history, or we have a history of laws of 200 years. But now the time has come that we need to develop best practices, a culture which is compliant of law culture, Compliance of law is very essential. We should get disciplined that whatever provisions are there, we can seek clarification, but at least we should have the spirit or the intent to comply with the provisions of any law, including the IBBI also. IBBI, now during these 5 years, you see how fast we have developed, how fast we have evolved. Initially, the process was corporate insolvency resolution process, a partnership or credit and control. Then 2 years, this year back, we again provided another process, that is pre-pay process. And now we are going further for providing cross-border insolvency process. So within this period of 6 years, I think new processes, maybe as a corporate resolution process, maybe pre-pack, or the cross-border we are going to have now, because there is a consultation paper, feedbacks have been received, and maybe very soon we may have cross-border insolvency provisions in our code, or a new chapter or new enactment, maybe like that. But we will have that kind of procedure. In this globalized world, certainly, I mean, age-old processes, maybe CPC, CRPC, or other provisions of law provided for the recovery or provided for the execution of decades. There are many number of kinds of laws, and especially on the procedure part, just I'm talking of, because any right cannot be achieved, cannot be enjoyed without good procedure. आप खाना बनाते हैं और आपका अच्छा कुक है, खाना स्वादिष्ट बनेगा क्योंकि उसने स्टफ वही है, process is different. And when process is different, when process is very simple and informal, certainly things take, or they can be articulated in a better way. They can be displayed and they reflect the result, I think, very soon also. So the procedure is a very important part. IBC also provides a procedure, and that procedure which is different from the earlier regime. And that procedure it is a kind of trial and error in India. Whenever you enact a law, it's not that we first apply to a particular state or particular sector or domain. We don't do this. We apply that law, we enforce that law. No doubt there is a phase-wise manner of application of law, but still, when we first phase, when we have notified for CIRP, certainly it was also kind of a trial and error. But because we had the experience of earlier laws, so we were confident that our experience of earlier laws means those defects, those challenges, those outcomes which we could have under earlier regime, that was not beneficial for the market, for the country as a whole, for our image in the world. So that's why we have envisaged, the government has envisaged a new process, but it was also kind of trial. But after 5 years, we have realized that hybrid mechanism, maybe a pre-pack, though there are not much of the cases, but maybe that pre-pack mechanism or hybrid mechanism may also prove good for the other area of this corporate also, because now it is restricted for MSMEs, but it may prove to be beneficial, or it may achieve the intent, it may achieve the objective of this code also. Now, when I look at the IBC, just I find that it provides for professionals, it provides for the process, it provides for the technology, and it provides the huge powers to the, confers huge powers on the IBBI. IBBI regulator, which is a unique regulator, regulating the professionals, service providers, IUs, IPS, and also engaging itself with academia, with the market for capacity building programs also. And I think time has come that there are 3 steps for to have successful outcome out of these statutes or the processes. First is that one should know the law. So public awareness, pre-awareness, before enforcing any law, I think if there is a awareness among the public, awareness among the stakeholders, certainly it will facilitate better compliance after enforcement. Now comes the implementation part or the enforcement part. If you have good regulations, if you have good rules, if you are able to address any kind of mischief or any kind of expectation or anything required for better resolution or speedy resolution of any process, certainly those are to be without any delay, without losing any time, needs to be amended, needs to be corrected. So the making corrections, that is corrective path, it is also to be seen that there is no delay where any corrections are required. So before enforcement, pre-awareness, awareness about the law. After enforcement, certainly the capacity building programs, and how regulations are to be written, or the law is to be amended or drafted, I should say drafted, in such a way that it does not require much effort to understand its meaning, or doesn't require any clarification from FSI. At least when I read any provision, then I should see that, oh, it's like the way we read any fiction or any novel. So we just understand the whole story. If we are able to draft law in such a manner, I know that the citizens of this country will be legally compliant. Maybe citizens means not only individuals, I say the persons staying in India, living in India, or the corporates or corporate body, both. They can comply with the comply with the provisions of the law, and we can have a very robust compliance and disclosure mechanism. Now, for having accountability on this issue of accountability, what we need? We need a disclosure regime. And I think it is the first law. We have MCA 21, and through that mechanism, we are able to have details about, or information about the whole, any company or on all the companies with the MCA. But the disclosure mechanism of this process, that is regarding registration and the affairs of the company. But about the process, we have CRPC, we have CPC, but what we don't have a disclosure mechanism as is envisaged under this law and the regulation made thereunder. That kind of disclosure mechanism is not provided, and it can be an example, but for fixing the accountability or having the accountability in the procedure, certainly disclosure mechanism is very essential. What you are doing, at what stage you are doing, please inform us. If anything is going wrong, we can plug that loophole that time only. We can remind that professional, oh, you have not, or you have overstepped here. So that kind of disclosure mechanism has been evolved with the help of devised with the help of technology. Certainly professionals now have a new regime of compliance and the disclosure. I think that has ensured that the process is going in a right direction, and process is very open and transparent also, because you have disclosed. So when you have disclosed, it becomes transparent. So for establishing transparency also, this disclosure mechanism has been envisaged under the IBC, and IBBA has tried its best that at all levels we have information, so that any loophole, any mistake, or any obstacle which a professional is facing can be clarified. We have issued number of circulars, we have issued number of amendments, notified number of amendments in the regulations, circulars for guiding the professionals. So no doubt, having vast powers under the code, IBBI has made its best effort to help the professionals and the market participants also. I think rightly spoken by Dr. Shadul Shafji, that we need a code of conduct. And code of conduct, why we need a code of conduct? Code of conduct establishes kind of best practice, a kind of, it generates, it establishes culture also. And code of conduct is very much required for every actor of this ecosystem, which is involved in the whole process. Because without code of conduct means this, it is a kind of process. How you should behave. When I say civil servant, that means a servant who should be civilized. When I say professional means a professional. He is different from a common man because he has to follow code of conduct. Unless he follows code of conduct, how others will follow, how his or its associates will follow. और गीता में भी शास्त्र में कहा गया है, श्रेष्ठ पुरुष जो आचरण करते हैं उसके बाकी जनता से सीख लेती है, और श्रेष्ठ पुरुषों का आचरण किया हुआ ही बाकी लोग उसका अनुसरण करते हैं. तो यदि हम चाहते हैं कि सारी जनता अनुसरण करे या डोमेन सेक्टर में जो लोग इन्वॉल्व अनुसरण करें, तो naturally we need to have a code of conduct, and the code of conduct is a good rider. यदि हम कहते हैं कि डॉक्टर अच्छा है, दैट मीन्स कोड ऑफ कंडक्ट, दैट इंक्लूड्स अ स्किल आल्सो. व्हेन आई से ये लॉ एसोसिएट्स या लॉ फर्म बहुत अच्छी है, और हम ये कहते हैं कि ये वैल्यूअर बहुत अच्छा है, बिकॉज एक सिस्टम को फॉलो करता है. यदि मैं कहती हूँ सिस्टम फॉलो, जस्ट गिव अ वेरी लेमस एग्जांपल, मे बी योर कॉर्पोरेट पर एवरीबडी हैज अ किचन. हम किचन में जाएंगे तो हाथ धो के ही किसी चीज को हाथ लगाएंगे, दैट्स अ कोड ऑफ कंडक्ट. उससे आपकी हाइजीन मेंटेन रहेगी, उससे आप इन्फेक्शन से दूर रहेंगे. सिमिलरली व्हेन अ कोड ऑफ कंडक्ट इज provided or envisaged, or it is developed by the market, certainly it will give best results. So under this code, technology, professionalism, and code of conduct, I think that goes, all these three go to help establish transparency and accountability for having a robust compliance mechanism in our country. And this code has established a new procedure, has given a, I think, basis for a new procedure that India can try. And I think age-old laws, maybe CPC or CRC, I'm not saying, but we need to have, this has proved that we need to have special procedures in special domain sectors. We need to have, because without special procedure, we cannot achieve that result. We cannot, I think, help the country to promote its economic growth also. So procedure is very important. This IBC has proved. Without a good procedure, without a transparent, accountable procedure, we cannot achieve any result, including the objectives enshrined in our constitution. Just one point, I think, at this stage, because we have a different procedure, we have provisions of for the Supreme Court's jurisdiction, civil and criminal. But I think now the insolvency has come to stay as not as a discipline, but I think it's a different, a special field of law which requires a different treatment from other procedures, I mean other matters. So in civil procedure, then this is the insolvency procedure, and we need to have economic due process also. We need to, I think, in times to come, because we are going through the phase of financial hygiene, no doubt. So certainly we need to have further researches, further jurisprudence to be settled by the Supreme Court in this direction, whether we need to have some, we need to supplement something more to the jurisprudence so that we can further strengthen the procedure. Maybe for individuals it has not been notified, but maybe general principles of law certainly applies to all. And if any jurisprudence is supplemented further, it will strengthen the procedure. It will generate command and confidence. It will generate command and confidence, especially for the professionals. And I know that all the professionals, they are doing their best under the matters which they are handling under this law. And in times to come, I think we will further see further evolvement, further evolution of this process. Maybe we may set an example before the world that they can also follow the way we copy UK and USA processes. I expect my dear professionals, my respected professional firms also, that they should set an example that other countries follow us. Now, after 70 years of independence, we have to be on the international map in such a way that if people quote us, oh, this is the process in India, why not? But how do we follow UK? We have a rich culture, we have a rich literature, we have a rich religious scriptures, and गौतम का न्याय दर्शन है, मीमांसा है बहुत सारी. क्या हम कुछ गाइडेंस वहां से लेके, क्या हम बेस्ट कल्चर नहीं ले सकते हैं, बेस्ट कल्चर डेवलप नहीं कर सकते हैं? क्या हमारे जो ग्रंथ हैं, हमारे जो मनीषी ऋषि हैं, जिन्होंने एक पीसफुल सोसाइटी के लिए अपने सारी मीमांसा, स्मृतियां, श्रुतियां सब लिखी हैं, क्या हम वहां से गाइडेंस लेकर हम हमारे इस कानून में सभी ग्रंथों से, मेरा मतलब ये नहीं है कि हिंदू ग्रंथों से, मैं तो जैसे बता रही हूँ कि जहाँ पर रैशनल है, जहाँ पर गुड राइटर है, जहाँ पे पीसफुल लिविंग सोसाइटी है, और पीसफुल लिविंग के लिए ये हमारा कोड भी है, स्ट्रीम का दूर करने के लिए कोड है. फॉल्ट हो गया है, घबराइए मत, आ जाइए इस प्रोसेस में, हाइब्रिड में आ जाइए, कोई बात नहीं, प्रीपेक में आ जाइए, जो इस तरह कोड है. और जो हमारा क्रॉस बॉर्डर इंसॉल्वेंसी क्या है, देयर इज अ जुडिशियल एग्रीमेंट, जुडिशियल प्रोटोकॉल, कॉपरेशन बिटवीन. अब देखिए क्रॉस बॉर्डर इंसॉल्वेंसी को देख लीजिए, व्हाट वी सी, एक्सेस होना चाहिए, जुडिशियल कॉपरेशन होना चाहिए, कोऑर्डिनेशन होना चाहिए. Those are the methods of resolution. So coordination, cooperation, compliance, these are the methods of resolution. And if these methods are articulated, drafted, implemented, practiced in that very spirit, certainly we'll be able to have result, and we have a basis, or we can further strengthen and promote new India economy and new India. With these words, I thank every professional and participant and all the panelists and respected members also. Thank you. Thank you very much. Jai Hind.
Thank you very much, ma'am, for sharing your insights with us. Your words have inspired us, and we are confident about the success of India's insolvency and bankruptcy regime. We have taken note of your suggestions for industry and would work on those. We are grateful for the support and guidance that FICCI has received from IBBI over the years. I would also like to thank our esteemed speakers of the inaugural session for joining us today and sharing their views with us. With this, we bring the inaugural session to a close. A couple of announcements I would like to make. I would request the audience to join in for the next session, which is a panel discussion at 11:45. And we have received some questions on the platform, and we will be relaying those in the panel discussion for the panelists to answer. Please do log in. Thank you so much.
Abba, can I stay on the call or shall I have to relog?
You can stay on this, sir.
Okay, thank you.
Chandan, I hope the streaming has stopped.
No, streaming is still there, but I have put the banner on the this thing platform.
So whatever we say here is not going to be relayed, right?
Video will not go, but audio, yes, it will go.
Can you stop the audio, please?
Let me check.
Esteemed panelists who will take us through the discussions. I welcome Mr. Rajesh Gupta, Chief General Manager, IBBI, Mr. R.K. Bansal, Co-Chairman, FICCI National Committee on Stressed Assets and Managing Director and CEO, Edelweiss Asset Reconstruction Company, Mr. Prakash Rao, Executive Director, ED and CIO, Indirect Investments, NIIF, Mr. Ashish Chacharia, Partner and National Head, Restructuring Services, Grant Thornton Bharat. The session will be moderated by Mr. Anup Rawat, Partner, Shardul Amarchand Mangaldas and Company. Over to you, Anup.
Thank you, Ava. I would like to extend my warm welcome to all the panelists here. We have virtually all the stakeholders that we could expect in this session. We have the regulator here. We have the veteran, experienced resolution professional, the veteran from financial sector, and the lawyer. As we all know, we have completed 5 years of the insolvency and bankruptcy code here. It is still evolving in certain aspects, and it has evolved in certain aspects. We are thankful to the regulator, to the government for bringing out the timely amendments to the code. And we are also thankful to the courts of the country, especially the Supreme Court, in settling some of the key issues around insolvency. In the hindsight, it's a mixed bag. We have some very successful cases. Nobody would have thought of dislodging such a powerful promoters in the erstwhile regime. As we move forward and step into the next phase of this law, where we need to now create more institutions which will strengthen the implementation of the code, there are certain questions which have come up. We are thankful that these questions have been recognized and the government have taken initiatives to bring necessary amendments in the law, whether it is the amendment in the main code itself or on the code and the regulations which interfaces with the insolvency code. Those initiatives have been taken. One of the initiatives that has recently been taken is to create a committee for review of the working of the ARCs, which have now come up with their recommendations. And one of the key recommendations that the Sudarshan Sen Committee on the review of the working of ARCs have come about is to acknowledge that the asset reconstruction companies must be allowed to participate in the insolvency resolution processes. Now, while giving their recommendations to allow ARCs to participate in the resolution processes, they have voiced certain concerns in terms of the conflict of interest that the ARCs might have when they participate in the insolvency resolution vis-a-vis their role as the institution which takes assignment of loan through their trust structures. So my first question is to Bansal Saab. He has more than decade old experience of handling the ARC business. My question to Bansal Saab is that what is this conflict of interest concerns that the RBI has, and how they have how the report now intends to tackle that?
Good morning. So my view is actually I can only guess why they are concerned on this. They have allowed ARCs to work in the sphere to basically resolve the cases. And when you acquire assets from different entities for different debts of different companies. Now, if you see the logic that ARCs can take over the assets and give a resolution plan under IBC. So, but they want to restrict that activity, that they don't want basically ARC to do only that work. So that is the whole idea, that they feel they can be allowed, but it can be limited. But overall, my view is perhaps it may not be so easy even for RBI to allow this unless, first of all, SARFAESI Act is amended. And how many ARCs are really agreeable to become resolution applicant and own the company? That itself will be a critical question to be seen in future. But naturally, the worry from the regulator is on that ground that they should not be doing only this work. Their main work should be resolution and reconstruction.
Yeah, and that is where we see that the committee has recommended that the asset under management of the AIFs or of the investment in the IBC should not be more than the asset under management through their SRs structures. So perhaps that's the intention. We'll see, but I think nevertheless it's a very, very important and a welcome suggestion, recommendation which has come from the committee. It will at least increase the resolution applicants base under the insolvency processes. Maybe it will also be work as kind of a momentum for the workings of the ARC, maybe they will see more capitalization, more participation, maybe more expertise will get created. Similarly, the other institutional framework which the SEBI has now recently come up with is the introduction of a special subcategory of AIF, which is called the Special Situation Fund, which will exclusively invest in stress assets and stress loans for acquisition in terms of the RBI norms as a part of the resolution plan. So my question, we have Prakash Raoji here from NIF. Prakash Raoji, what is your expectation and where do you think that, how this new institutional framework will help in increasing the participation and increasing the capabilities of AIFs to offer more resolution under the insolvency framework?
At the outset, let me first thank you for having me here. And also, Anup, you have brought in some very important points so far. Just before I step into the topic, if I may take a minute, during the entire career that I had in the banking sector, we have always grappled with the problem of the stressed assets and how we can resolve this. And I think the Government of India and Reserve Bank of India have come up with a lot of things, but IBC has come definitely as a breath of fresh air. I think it is, along with GST, is one of the most important reforms that the country has taken. See, at NIF, we are also 5 years old approximately, and we have been having interactions with a lot of international investors who have been tracking this and have literally been complimenting the country for coming up with this. And you have mentioned that there has been a mixed bag. I would actually go to the other extent and say that it has been a phenomenal success so far. As Indians, we want things to be much, much better than what they are, and that's the way only improvements happen. But I think, 45% recovery from the assets so far has been phenomenal. So that's, I think I thought that I should mention about the IBC. And the second most important thing is this has been very dynamically changing according to the needs and according to the experience that we have gained. That again, I think we should give credit to both IBBI and generally to the government itself, that I have not seen any single law that has been amended so many times to suit the needs of the hour. So this is, I thought I should make a point. And coming to the introduction of, a special category of special situations fund under the AIF guidelines. See, I personally think that the current AIF2 structure does provide a lot of leverage for investors to come in through the AIF structure, and they get the pass-through status. So to have an AIF1, I do not see any major differentiation except perhaps, when the local insurance companies want to invest, they can actually invest up to 20% instead of 10% of an AIF2. So that is one possible thing. And second thing is the exemption from the diversification requirements that they have brought in. That could also be something that while AIF itself would like to diversify, obviously they do not want to just resolve one or two assets. But if there is a huge asset that an AIF has acquired and they are in a position to just limit themselves to that asset. So that diversification requirement has been done away with. That is also, I think, it's a great enabler. I think it is an interesting experiment tweak to the regulation, but I don't think it's a major change from what it is. Now, the other point that comes up is whether we can have an active secondary market for all the assets. Is again something that whether the AIFs can help is again something that I have been thinking about it. But my view is that international capital is willing to come to India, provided the structuring is right, the pricing is right, and they are actually seeing the returns that they would make. Obviously, this is a higher risk investment, and they would like to make returns. And I don't think the country should grudge if somebody is taking the risk and turning around and making money on that. The third point that I want to make is, when the AIFs come in, they can actually employ specialized turnaround professionals and sector experts, and that can actually help because of their deep pockets. They can help actually turn around the assets much more than just selling them and stripping them and selling. So I think protection of capital for IBC as a whole is an important thing, and the advent of AIFs into this will not only protect the capital, maybe change the management and bringing in governance standards. And I think AIF 1 is an interesting tweak, but already there are a lot of enablers provided by SEBI.
Thank you, Prakash Rao ji. I think it's a great insight. What we can expect going forward. Coming back to the key procedural aspects of the IBC processes. One of the key stakeholders in this IBC process is the financial creditors who constitute the committee of creditors and who have also been entrusted with the task of taking the commercial decision to approve the resolution plans. Of late, some of the decisions of the COCs have been questioned. In fact, we have seen in the Parliamentary Standing Committee of Finance report where they have emphasized on the need for a kind of a code of conduct for the Committee of Creditors. Now it has created conflicting views. Some section believes that the Committee of Creditors should be left to decide the things on their own and should not be bound by any specific processes. The other section do believe that given the important nature of the decision making that happens at the COC, it is very important that there is certain code of conduct that becomes applicable to them. In this regard, IBBI has also published a discussion paper where they have sought to bring about certain checks and balances as far as the COC working is concerned. Now, we do have with us Rajesh Kumar ji. I would request Rajesh Kumar ji, if you could please share with us your views on this particular aspect.
Thank you, Mr. Rawat. Of course, I think to some extent, you've already given the pointers in terms of the code of conduct, which may be required for the committee of creditors. We are feeling in the same direction that some kind of code of conduct definitely is required for the committee of creditors because of the various kind of things which are there, like the Insolvency and Bankruptcy Code, as all of us are aware, it envisages market-led solutions in the insolvency space, driven by professionals and committee of creditors predominantly. While all the other professionals who are involved in the process, whether it be the insolvency professionals or the registered valuers or the information utilities, they are regulated entities. One of the key stakeholders, that is the committee of creditors, that is still not really regulated by way of the IBC processes and the systems. The bankers and the individual bankers who are forming part of the committee of creditors as financial creditors, they are regulated by the Reserve Bank of India. So we are finding some kind of a gap in the entire process, which was necessitating some kind of a code of conduct to be made applicable to the committee of creditors. On several occasions, questions have been raised in various fora about certain activities or actions of the COCs being detrimental to the objectives of the code. So it was being felt that there is an urgent need to devise an appropriate mechanism to effectively guide the COC in its day-to-day functioning. The COC has a statutory role and discharges a sort of a public function. It must therefore apply the highest standards of duty of care and follow the due process to be fair to all the stakeholders. It should also act in a transparent manner in discharge of its responsibilities. Judicial pronouncements to a large extent have clarified the kind of a role, the supremacy role and the responsibilities which the COC has been assigned in terms of establishing the primacy of commercial wisdom of the COC in deciding the fate of the corporate debtor which is undergoing a corporate insolvency resolution process. Many of the stakeholders, seeing the past conduct, say around 4 years plus, have expressed the need for having a code of conduct for the COC. The 32nd report, as Mr. Rawat also was mentioning, of the Parliamentary Standing Committee on Finance has also recommended the same, stating that there is an urgent need to have a professional code of conduct for the COC, which will define and circumscribe their decisions, as these have larger implications for the efficacy of the code. It is observed internationally also, there have been large number of precedents whereby the COC with the corporate debtor are subject to certain rules and regulations for their conduct as part of the insolvency resolution process. For example, in the United Kingdom, there exists an elaborate guidance issued by the Association of Business Recovery Professionals in conjunction with the recognized professional bodies on what might be expected out of the COC. Similarly, in the US also, the creditors and other stakeholders, they play an important role in acting as a watchdog over the debtor's conduct. And the section 1102 of the US Code places responsibility of interest of those represented by the committee, but not appointed on it, on the members of the committee. The COC institution is key to successful conduct and resolution of companies through the code, and the code has empowered the COC to choose the best possible resolution from the market and provide for any measure as part of such a plan to ensure sustained life of the company, sustained resolution of the company. The responsibility, of course, comes with adequate accountability. Specifying a code of conduct is expected to promote transparent working of the COC and make participating members accountable for their actions during the process. We feel that the code of conduct shall also promote higher responsibility, make decisions in the interest of all the stakeholders instead of their own small self-interests. It is likely to also strengthen collective action, which is a fundamental principle underlying the code. The board already has put out a draft paper in public domain for public comments and proposes to put in place a suitable code of conduct for the committee of creditors. Practice of insolvency and restructuring is a complex and a varied one, and it may be difficult to conceptualize and codify every possible situation or a scenario. Accordingly, the proposed code of conduct establishes broad principles that can be applied to every situation as the guiding principles. It also draws from the ethical norms on which the COC is expected to function and shall be acting as a guiding light for the COC in conducting itself. The code of conduct was put in public domain, the draft code of conduct. Comments have already been received, and presently those comments have been compiled together, and we are in the process of, in conjunction with the Government of India, taking a final decision in terms of release of this code of conduct, which we feel would be good for the ecosystem in its entirety.
Thank you, Rajeshji. I'm sure that the way IBBI has been very active in tackling the issues that are faced on an ongoing basis. Even this issue will be resolved with the help of the other stakeholders who would have submitted their suggestions with you, and an acceptable model code of conduct will come out, which while takes care of the process aspects and creates perceptible and more reliable, consistent approach, and at the same time gives enough flexibility to the COC in taking the commercial decision with respect to the different IBC transactions, and each IBC transaction is different. In some IBC transactions, your assets are regulated, in some they are not. Some requires a unique thinking. So I'm sure that that flexibility with the COC will continue to be there. That also takes us to the similar suggestions, now which has come up, which MCA has now put up for public comments, which were put up on 23rd of December 2021. And some of these are very, very key suggestions which have come out, and they actually echo the issues that we face today. Some of the issues are such as, admission of company under the CIR process. What should be the level of scrutiny that the NCLT should go through? We have seen in many cases now that the adjudicating authority goes beyond the issue of the financial default and goes on into the reasons of what caused the default, what could have been the ways and means in which default could have been resolved. Those are some of the qualitative issues which right now should not be within the purview of the adjudicating authority. And it has rightly been acknowledged in the proposed amendments, where it is suggested that once the information utility gives a record of default, that record of default should be adequate for admission of a CIR process. Similarly, there are other amendments in relation to the look back period and also on the completion of the hearings and the approval of a resolution plan. We have a very experienced resolution professional here, Ashish. We have worked together, and I know is very, very knowledgeable and has a thorough knowledge of the workings of a company under insolvency. So Ashish, would you like to touch upon some of these key amendments, and what is your view on these amendments, and what you think could be proposed in addition to as a modification to these suggestions which have come out?
Thank you, Anup, and very good afternoon to all the participants, and thank you to Vicky for giving this opportunity. I think these recent amendments are quite focused, trying to address some of the pain points as the law is developing. I heard some of the earlier speakers also in the inaugural session say that this is one of the laws where one has seen the maximum number of amendments because the government, the regulators have their ears to the ground. They are able to see the challenges that the professionals, the resolution applicants, the COC members are facing, and trying to do course correction along the way. And I completely echo, I think, Mr. Rao's comments that this has been a fantastic success for the country as a whole. The IBC. Of course, there are improvements required, and that is another step in this direction. The recent proposed amendments. Specifically, if we, you mentioned a couple of points regarding avoidance transactions. Also, the focus on, getting speedy resolutions, from or the approval orders from the NCLT. Some steps in this direction are very important because we have seen cases where clients, where successful applicants have. The COC has approved a plan, but they're sitting for one reason or the other. They're sitting in various NCLTs for more than a year, awaiting approval. And in that period, the value of the company does tend to deteriorate. The vendors, suppliers, they lose faith. So I think this proposed amendment whereby there'll be again a timeline. This was really missing in the code earlier, because I think while the timelines were prescribed for almost every step along the way, they spoke only up till the time when the plan was submitted to NCLT for approval. Now, what's being suggested is, the NCLT should endeavor to give an approval within 30 days, otherwise record, reasons for that. So basically, it is a step in the right direction. We all understand the constraints which Honorable NCLT is working in, some of it which have been addressed recently by adding more members. But I think this is a very important attention that's been given here. Talking about avoidance transactions, again, there have been instances noticed whereby after filing of a Section 7, Section 9, Section 10 application for admission of a case under CIRP. So finally, once the creditors have exhausted most options, whether it's restructuring, in the erstwhile June circular, or in the earlier days, SDR, one-time settlement, and all the options once it's expired, we tend to see finally the creditor makes an application for admission into IBC or CIRP. But thereafter, while there is a timeline, a directory timeline prescribed for 14 days for admission, we have seen cases which have dragged on for more than 24 months, even longer sometimes. I mean, the average now, I don't have the specific statistics, but I could easily say, you Anup, you're dealing with many of these cases, 3 to 6 months at least, if not more. And in some cases, it has been intentionally kept behind with one way or the other. Now, what this happens here is essentially because the code prescribes the 2-year look back period for related party transactions and 1 year for unrelated transactions. And that date is from the date of admission. So in the interim, if this period is lost in the courts for whatever reasons, the creditors and the RP are, their scope of look back has shortened, right? I mean, while it is still 1 year or 2 years, but the point is going back from when. So the period during which the transactions are likely, avoidance transactions likely to have happened, or after filing of CIRP. I think a proposed amendment here is that the look back period should be started from the date of filing of such an application rather than admission. While I think it's a good proposed move, I would actually go one step beyond that, or one step further, and we have given our comments on this as well. That why not look at it from the date of default? Why look at it from the date of submission or date of application in the NCLT? Maybe we should consider whether date of default is an important date to consider and look back from there. This is particularly important in India because the laws around fraudulent trading or insolvent trading, actually that's a better right word, the insolvent trading, the penal consequences of that are not very well defined. So directors, if you look at some of the mature regimes, the directors who are engaged in insolvent trading, because directors, promoters obviously know when the company is, they know much before the creditors do, and if they continue to trade in that business while the company is insolvent, it is actually a fraud on the creditors. So there are heavy penalties for this in other mature jurisdictions. In India, we are still, not there yet. So that's why this look back period is a very important provision. So I think some of these proposed changes, there are 6 or 7 changes here, but some of these changes are quite important. And let's hope that these can be implemented very soon. Back to you.
Yes, Ashish, I think, yeah, thank you, Ashish, for sharing your thoughts on this particular issue. We have actually suffered because of some of these issues, because while the expectation generally from the creditor side is that the resolution professional should look into every possible wrongful trading that could have been conducted, they have been undertaken. But unfortunately, the statutory provisions were not very clear. I think what this specific amendment does is that, one, it does extend the look back period, and you have to now see it from the date of the filing of the application. It also covers the period between the application and the admission. So it's actually, in effect, it is much larger period now. So, and especially given the fact that the adjudicating authorities, take more than 3 to 6 months, you were actually quite, conservative in saying. So I would say that, it's actually, in some cases, it is more than 9 to 10 months and touching a year or maybe more than that. Then, this period becomes very uncertain as to, what will happen. Because if you look at the current look back period, you will then only cover this 1 year and plus 1 year more from backwards. Now this amendment will allow a much larger period. And also, I think my personal suggestion when we give our suggestion on these proposed amendments would be that even the fraudulent trading provisions need to be elaborated a little more. Right now, while there is no timeline fixed for a fraudulent trading analysis, but to what extent the management of the company can be made responsible, those provisions still require some more clarity, especially subsection 2 of 66. Some people interpret that to be a standalone section. Some people link it to the wrongful fraudulent trading alone. So that has created a little more of a confusion. I hope that some more clarity will come. We'll also give our suggestion. Now, also, one of the connected issues, and this question is to Bansal Saab. Bansal Saab, we have seen, some doubts have been raised. A lot of doubts have been raised. The kind of recovery now that we are seeing. The recoveries are very dismal. I mean, they're in the range of 5 to 10%. Now, some of the things which are intriguing, Bansal Saab, is that when just before the insolvency, these companies were attempting a resolution either under the RBI circular or otherwise. Then the kind of resolution plan that was talked about did not contemplate this kind of a huge haircut. But suddenly, when the companies go into insolvency, and when the resolution plans are invited, then the resolution plan comes in this range. What do you think is the actual reason of why this massive deterioration happens? Is it because of lack of appetite, or is it because of the lack of understanding of the asset? What is the reason according to you, and what could be the possible measures which should be taken to correct or to improve the values coming out of the insolvency? Bansal Saab.
So Anup, basically your question actually is covering a lot of areas. Frankly speaking, what will be the value of the asset depends on the type of industry, depends on the type of business, how much debt it has. Now, we have seen those reports, raising concern. That is how the COC is supposed to have some code of conduct. There was a recommendation in the report of JNC and IT committee that there should be some minimum amount or maximum on the haircut. But the point is, you're right. I think sometimes a company which otherwise was talking of restructuring and not giving a big haircut, suddenly in IBC, it starts giving a bigger haircut. Now, there are two parts to that. When we talk of restructuring, the haircut may not be apparent, though there is a haircut. I was heading CDR for 3-4 years. So I have seen when you convert into CRPS, a big amount, it's a haircut, nothing but haircut. When you convert a big amount into equity, that is also a haircut. So, like say one telecom infra case, I remember when the debt was 10,000, 12,000 crore, and finally just because of CDR and SDR, the debt came down to about 4,000. So, and sometimes the company claims that I have paid that much 6,000 crore. But my limited point is that 6,000 crore which got converted into CRPS and equity is nothing but the haircut, which you may not agree directly. Now in when you go to IBC, it will look apparent. The business, I mean, especially the type of cases, the companies which are being referred, one was in telecom business, it had some oil fields, it has some electronic business and all that. Now, you look at the businesses, no? Finally, IBC will give you the value of the asset which is there. If you see, and we do this always about IBC, that it has done very well. What it has done very well is just to ensure that in India, promoters, you can get rid of the promoters, otherwise it was very difficult in our country. Last 10 years, 15 years, I have been seeing in the banking or even in ARC, other than SURFACE and which doesn't work for performing operating assets. So then what option you had? You had option of only restructuring still. So IBC has given that power first time. If I see the out of first 12 cases and if I see resolution happening, 5 were steel cases by the way. And only in 5 those resolution happened, though at a different price, ranging from 90% to 25%, even there. Now, you can argue with me that steel should give 90% value, but that can happen only in SR steel. Just because SR steel was a good asset, plus Arcelor was very keen to put up their facility or to come to India, they gave a good value. But the same case was there in that Monet also, which gave some 25 cents or something. So you can't even go by the just industry. Now, if I exclude those actually 5-6 cases, including Binani Cement, which gave 100% virtually, the even IBC recovery is hardly 22 cents. So it's a question of value of the asset. If I don't have the value, today if I go to Jet Airways, Ashish I think had handled, if I remember well. So I mean, what is the value there? They never had except 2-3 planes. I think there also there were loans. So you can't have a value to those rights. What is happening in EPC company? You have only claims left. So what value you will get in EPC company? There is slight interest in roads, but rather than roads, EPC companies may get value of only 5 cents, 10 cents. Now you will say COC should not agree to something with below 25 cents, 20 cents. You can make a rule. Then how do you follow? Rajesh ji also said that bankers are not governed by IBC. Certainly, bankers are governed by IBC. They are not governed by RBI, governed by the bank. And if you start raising that issue that they should follow, so I'm only worried that this will lead to further delays because then borrowers or people who are already delaying things, they will start saying the COC has not followed the code of conduct. And again, one more issue for going to courts. So we should accept as a country. I think the value will be in the asset, whatever it is there. You may get 5 cents. By the way, in international, and we as an ARC, we have started retail business. In credit card portfolio, internationally, the price given to them is 4 to 5 cents. Nobody raises that question why you are getting only such a less amount. Even today, we buy the retail assets at about 10 cents to 12 cents in many cases. So it's a question of the asset, whatever, I mean, the value is left out. What will happen otherwise? You will not approve the scheme, you go into liquidation. What is happening in liquidation? You must be seeing those figures. Whatever cases have gone into liquidation, hardly 5% have reached some conclusion. 95% are still struggling. You mentioned 3 months, 6 months for admission. I have cases where 3 years or 2.5 years case are not admitted. Yesterday only I got by the way, in one case, the plan was approved in 2018. And yesterday NCLAT or NCLT sometime back gives the time to the RA to give a bank guarantee, which is not given for the last 3.5 years. So, I mean, so what is happening as a lender? Also, perhaps we have to have some say, no? Lenders, and in fact, our country, the lenders are least say. You can get haircut from the flat buyers, you can get haircut from everyone else. Fees is also borne by the lenders indirectly, directly. So nobody has actually, frankly speaking, nobody has sympathy to lenders, but unfortunately, that's okay. I'm only saying all things are fine. Transparency is good enough. But you must keep in mind that the asset will give you the value, whatever it is worth for. And there has to be strategic interest in that. Otherwise, you will not get a value.
So, Anup, if I may just add to what Mr. Bansal has said, I fully agree with what Mr. Bansal has mentioned. See, ultimately, it's the willing seller and willing buyer who are getting into the asset, right? And if the buyer is looking at his strategic value for him and the assets underneath, they create a value for him, obviously he is willing to put in that much more. it is not the process actually, it is the value of the asset that decides the recovery of the particular thing. And that needs to be understood. And I also go back to the point that Mr. Bansal made on the Committee of Creditors. See, basically, if you look at it, the success of the resolution of some of these assets is because the Committee of Creditors have taken those calls. And by putting in an additional layer of regulation, in fact, Supreme Court has also said that the powers of Committee of Creditors are not justiciable. Those are the words used. So by putting in an extra layer above them, then it could actually lead to further delays. And that the overall, IBC has done so many good things. And by in the enthusiasm that the Committee of Creditors may not be commercially oriented in respect of others also, is actually putting a little bit of an aspersion on the COC, because these are the commercial creditors, these are the financial creditors, these are the people who are interested in recovering as much as possible. And I think we should also give it to them a little, saying that they will take commercial decisions. By all means, we should have some sort of a code of conduct, but I think a regulation over the Committee of Creditors could perhaps take away some of the benefits that the COC is empowered with.
Anu, I
Thank you.
just want
Yes,
points.
Mr. Bansal.
No, first of all, I thought having worked in public sector bank, I thought the bankers are not taking decision much about the transparency and the procedure. So this talk of code, I think, goes the other way around. So in fact, they are worried. We should push them to take decisions sometime. The other point which I wanted to just highlight, and I've spoken to Mr. Sahu at that time. The first resolution in IBC happened when the case was ours. It was Synergy Dore. The haircut was 94%. Okay, the first case I'm telling you, the first case under IBC approved. But nobody made any noise about that case. It was a small case, but still haircut was 94%. But now suddenly it is becoming a big issue. So I think we need to be careful. I mean, I just said, because that first case belonged to me in our real-wise ARC, we took 94% haircut.
No, absolutely. I think Bansal Saab, Prakash ji, I think both of you have made valid points. Definitely, I mean, I think the value has to be from a perspective of, how good the asset is. And Bansal Saab, I think you made a very important point that, in some cases, you may not have that assets. You took the example of Jet or, an EPC company where, they may not have the asset. So the value will depend upon what business they have. I think from that perspective, one relevant point to consider is that, how fast you can run the processes in the companies where, you do not have assets to, prove the value. And it is only the business, which can sort of fetch any value. In that context,
Even in such cases, the liquidation takes 2-3 years, by the way. No NCLT is in favor of liquidation.
Absolutely.
When you have no asset. By the way,
When
sorry, I
you
may
do
sound
not have any
very
assets.
cynical. I may be sounding cynical, but the code of conduct is required for NCLT and NCLAT. Which cases should admit, which frivolous application they should not admit, how much time they should take for admission, how much time they should take after reserving the orders. I mean, they are destroying the value in that sense, if you really ask me. But I don't want to make a statement because anyway, nobody will like it. So let's leave it.
Yeah.
But otherwise, a serious requirement is code of conduct for members of NCLT and NCLAT, and the rules for conducting the business at those two forums.
I think that's a separate discussion, a very lengthy discussion altogether. But coming back to this particular issue of insolvency processes for companies which do not have significant assets of their own, I think my personal view is that the pre-pack regime which has been now introduced for MSME should be introduced even for those cases as well, because if you do not resolve them quickly, the chances are that the deterioration will happen very, very fast. Now, just I would just like to ask this question to Pankaj. Pankaj, given our experience so far, if you look at how many EPC companies have been dissolved, or how many similar cases where they do not have enough assets, most of them have either gone into liquidation or have ended up fetching very, very dismal value. What you think from IBBI perspective? Is there a need to quickly introduce the pre-packs for those cases?
Well,
Anup, I presume you meant Mr. Gupta, right?
Yeah, right, of course.
Mr. Gupta. You mentioned
Oh, I'm so sorry,
Pankaj,
Rajesh Gupta ji.
yeah,
Rajesh Gupta ji.
Yeah,
Sorry,
fine.
I'm sorry.
Okay.
Rajesh Gupta ji. Rajesh Gupta ji. Sorry.
So of course, I think
My apologies.
Absolutely not problem. While agreeing with Mr. Prakash and Mr. Bansal regarding the kind of value which is being given out as part of the recovery efforts under the IBC, one of the foremost objectives of the IBC in any case is not really recovery. It is more of resolution per se. However, having said that, you are right that whatever recoveries are possible are dependent upon the kind of value which the company was having or the unit is having when they have entered into the insolvency. For example, what the data which we have till March 21, the companies who had entered insolvency, they had assets valued on an average at around 22% of the amounts due to the creditors. This means the creditors were actually staring at a haircut of around 78% to start with. IBC not only rescued these companies, but the haircut also got reduced to 61% for the financial creditors. So we have on one hand cases like Goteranga Minerals and Orchid Healthcare, etc., wherein they had literally no assets when they entered into IBC. There were no employment, there were no units also literally, and they owed together over 8,000 crore to the creditors. Obviously, creditors in such case are staring at a 100% haircut. On the other hand, we had cases which we already discussed, like the Binani Cements or the MBL infrastructure, which actually yielded a 0% haircut. So it has to be also understood as to why in certain cases the IBC yields a zero haircut, while in certain other cases the haircuts are 100%. So it will depend upon, as Mr. Bansal also was mentioning, regarding the nature of business, the business cycles, the market sentiments, the marketing efforts which have been made, and of course the assets which a company is having when it is entered the IBC process. So haircut has to be seen in relation to the assets available on the ground and not really the claims of the creditors. Now coming to the pre-packaged insolvency resolution process, it has been started initially for the MSMEs as of now, and we are not actually seeing the kind of traction which was expected for the number of cases which are getting filed. Only around 3 to 5 cases have been filed till now. Maybe initial 6 months and all have gone after the rules came out in April last year. In understanding, also were trying to disseminate among the various stakeholders and other things. But hopefully, if this kind of process gains ground, then maybe on a selective basis, this is again more of a personal opinion, one can consider in certain the cases, the committee of creditors can decide to probably let the existing set of management, not only for the MSMEs, even the larger players also, continue with the possession of the unit and control of the unit. That is depending on the kind of comfort the committee of creditors or the financial creditors may have with the existing set of management in the promoter. So yes, it can aid in maybe speeding up the entire insolvency process in terms of the timelines, because we are aware that most of the assets of the companies under distress is more of a perishable commodity, which is like a melting ice. The more the delays, the more is the erosion in the value of the company, more is the erosion in the value for the stakeholders. Even recently, Reserve Bank of India also has done one study wherein they have tried to understand after the declaration of the NPA, how much time a company has been taken to file an insolvency. And depending upon that, they have tried to work out the percentages of recoveries for the financial creditors. And it is obviously no big kind of a revelation that the cases wherein the insolvencies have been filed early, the recovery percentages for the financial creditors have been higher.
Rajesh ji, thank you for your thank you for your input on this, and it's good to know that at least you at the IBBA also feel that this can be extended to other cases. And I was actually talking specifically in context of the cases where you do not have significant assets, but they have a significant lending. and the value of those companies primarily depend upon the business that they are running, especially the EPC businesses in the country. Ashish is also part of some of the EPC processes which have now gone into liquidation, and I'm sure Ashish would also be looking at some of the cases in pre-pack for MSMEs. Ashish, what do you think is the reason now for pre-pack not being very successful in MSME, and do you see that the reasons which have sort of led to a damper sort of a response in MSME would also persist in case we introduce it for the larger companies? What's your view, Ashish, there?
So, firstly, apologies to the panel audience. I will have to drop off on your question regarding pre-packs, whether successful or not. I think it's a bit premature to be able to judge on that whether it's successful or not, because I don't think there have been that many cases yet to be able to learn from that experience, or maybe it's not come to our desk or my desk where I have seen too much. I know that lenders have been evaluating those options with various MSMEs, but I haven't seen too many conclusions as yet. So, but I think it's a good idea that it has started with smaller companies to learn from there and then to implement it for larger cases. That I think is actually the other way around compared to what happened when the IBC started with those big 12 cases. And I think the learnings from that, from the smaller cases, will help us do this much better in a shorter time for the larger one. And I definitely think that pre-packs is the way forward, in the interest of quicker and faster resolutions. Regarding EPCs, I think your comment, I haven't personally, dealt with any pre-pack in EPCs, but as I think Mr. Bansal was earlier also mentioning that there's hardly any tangible assets in these. It's essentially the intangibles, the credentials that are available with the company, which are important. And swifter resolution can possibly attract some, new players or funds which are looking for these credentials for future. Because the infrastructure story in India, I believe, is still very good. And with Mr. Prakash also, speaking about, he's leading the NIIF, and there's so much focus of the government. I think that's one way to improve recoveries for EPC companies. But so far, the experience on this EPC companies has not been great. So that's all from my side, and I will like to excuse myself from this.
Sure. Thanks,
thank
Ashish.
you.
Thanks, Ashish.
Thank you all.
Just taking this point
Apologies
forward.
for dropping off 15 minutes earlier. Thank you.
Thank you, Rajesh. Just taking this point forward, Rajesh, one specific aspect of the pre-packs for the MSMEs, which is, the lengthy process pre-filing of the application and after filing of the application, vis-a-vis the overall value involved. That perhaps, in our experience, has been a cause of concern, both for the lenders and also for the corporate debtors. As compared to that, if you see the larger transactions, there, both these processes and also, the other processes on valuation, whether, it involves appointment of the credit rating agencies and other things, they are much more accommodative as compared to the smaller MSME. So therefore, I think to look at the successes of this pre-pack process for the MSME, to be the basis for moving on to the larger cases, I think there's some qualitative assessment need to take place there. I would request Bansal Saab if he has any views on this aspect.
I agree. I think pre-pack, as Ashish also mentioned, that should be the approach in future. and partly because I think some assets which we need to resolve may not attract the strategic interest. And as you rightly mentioned, like say EPC company, there are a lot of claims. But if there are assets and some good claim, it will attract. Like say we have seen that happening in Soma. So sorry, I'm just using sometimes a name, but just to give an example. So it worked. It worked there. So I'm saying if you can resolve the asset, because the biggest problem in EPC companies is you need to have bank guarantee. And when banks otherwise do a sale under IBC or anything, they will not continue with the bank guarantee. So I think you have to work around the cases, do some sort of a pre-pack. Even other cases we are seeing now in the market today, a lot of cases people are talking, even outside IBC, people want to buy some asset, but then you don't have a way out to get rid of many statutory operational creditors or even otherwise a lot of other cases. So people prefer IBC route. We did that, in fact, in one or two cases where buyers want to do that and take the company to IBC. So I think IBC is the right forum in that sense overall. Now, pre-pack, the only risk which we have been discussing in the larger corporates is one was, of course, again, the moral hazard, whether we should give back the company to the same promoters. The second one was whether people can misuse it by getting rid of statutory liability under operational creditors, and whether financial creditors and the borrower can collude with each other to give a hit to government. So I think we need to take precautions on that. But otherwise, pre-pack should be the right way to do the resolution much ahead with actually much before the case becomes very bad. In fact, that is how it will work. So today we have systems because of before that. See, IBC is doing a great service, at least by creating a fear, at least in the existing borrowers, not to take the financial creditors granted. But if we allow this type of thing, and even in, like say, UK, we have the debtors in possession model. It's not as if it is something which is not done even in US. So I think we can think of that. The purpose which when we came out with IBC, it was required in that shape, because otherwise Section 29A has worked. Otherwise, people would have taken the same restructuring and continued in this country. First time we have seen that a cleanup exercise has happened. Today, banks don't have many cases, in fact, to clean up. But in ARC, if you ask me, we don't have many cases to buy out the debt because there are not many left. Most of them you have resolved, right? So I am saying it's a very good thing which has happened. So in future, perhaps we should look at pre-pack, but then speed has to be increased. I have seen only one case getting admitted, MSME, and that case also has no seen any resolution. The whole purpose of pre-pack was faster resolution. So if that purpose is not served, then I think maybe we will not be doing the right thing. I think we should look at this. Maybe initially government may start with mid-corporate. If it is not comfortable, you can fix a debt limit of 500 crore or something. Because above 500 anyway, if it is going to NARCL, we can think of below 500 goes to, let us say, pre-pack.
No, absolutely. And I think some of the concerns that, the statutory liabilities will be reduced and it will be used as a platform. I think there, they already have those checks and balances where if there is any haircut for the operational creditors, then they have to run a Swiss challenge for the process. So I think those inbuilt, checks and balances are there. I think it's a good time we really think of introducing it for some of these areas, as you suggested, Bansal Saab, and as others have suggested. I see that we do not have too much time left. We have some questions here. There are some questions too for the other people who are with us, who are in the introductory session. We have the honor of having Mr. Shroff also here. He's our executive chairman. He's the national practice head of insolvency practice at our firm. I see one question addressed to him. Sir, are you there? Can I take this question? Can I read this question? This is for you. Mr. Shroff, I see he's logged in, but he's on mute. Maybe okay. So I'll just take this question then. This question again is on pre-pack. Is from Anish Nanavati. He's one of the resolution professional. The question is, pre-pack insolvency have not taken off as one would have wanted, despite its obvious advantages. What are the likely reasons for the same, and what changes may be required to the statute to improve its acceptance? So, Bansal Saab, why don't you take this question? You have said that there have been only one filing so far. What do you think is the key reason why it is not taking off in MSMEs? Is it because of the process? Is it because the process is not certain? Or is it because there is any other concerns amongst the corporate data of what it can lead to? Or is it that the adjudicating authorities are not facilitating the process? What is your view on this?
I think I will just try to give some my view. One is perhaps it is not well understood even now. Even lenders are not sure how it will work because there is still a moratorium. The whole purpose of actually the pre-pack should be I should make a plan beforehand, go to NCLT and get it stamped. That is the way it should happen in pre-pack, but it's not happening that way. So if you have to go through the full almost like CIRP process, then it doesn't make sense. That is one reason. Second, I would say is the reason is most of MSME will have only one bank. Now, bankers will find it easy to resolve the debt with that guy outside also. No, why to go through IBC then? I mean, in that case, I can do a settlement with him. I can do a restructuring. RBI allows some forbearances on restructuring for MSME. So if you really see the way we have started for MSME, I think there was not much need. It was just a message, I think, by government that we will allow this. But the second stage need to come, I think, for mid-corporate. There you will find some action. In MSME, I doubt whether this will work.
So, Bansal Saab, is it therefore correct to say that the second phase of pre-pack would only be basis the success of the first phase? Because we know that the first phase, which is for the MSMEs, has completely different set of circumstances, the lending portfolio, the quantum, and the other mid corporate or the other larger ones have a completely different needs. So is it correct then to say that the second phase of pre-pack will only be started if we see success in the first one?
But that will be to some extent, in my view, a mistake because first phase, if we see that in an MSME, not many cases have come, and based on that, we take a view that we will not do it for mid corporate, then my view is it will be a mistake because, as I said, for MSME, you don't need it.
If I may just add a point on the pre-pack for the MSME.
Yes, Prakash.
See, the thing is, bankers will be able to do it if they are comfortable with the promoter. Okay, they can do it outside of the IBC and they can have a one-time settlement or something they can do. If they are not comfortable with the promoter, then the pre-pack will not work because pre-pack is between the promoter and the lenders, right? So I think in MSME, if I may add to what Mr. Bansal had said, this could be an issue why MSMEs are not coming to the pre-pack so many. And the second point that Mr. Bansal has mentioned about the pre-pack being extended to the others is also right. I agree with him because just because it has not succeeded in an MSME because of different circumstances, we should not say that this doesn't work at all. The third thing is the speed at which the IBC admits it and adjudicates it. That is the most important thing. And of course, there are moral hazards apart. I think if we are able to get to a speed on this, then it would work very well. The fourth thing is we haven't discussed about NARCIL's role. I think if banks actually transfer some of these assets to NARCIL, and NARCIL is able to consolidate these assets from different banks and different promoters, actually, and then they can be sizable targets for special situations funds, because then there will be a size. They can employ people who are capable of turning them around and bringing in a different perspective. And that's again, the security receipts that are backed by those type of assets. Actually, there will be value created, and they can be marketed within on an online platform as well. And that way, you can actually bring in sale and purchase of the security receipts online like any other securities. I think the role of NARCIL in all this could be also an important role.
Absolutely. I think that's a very valid point, Prakashji. I think with the debt consolidation combined with the pre-pack regime, I think it takes away the uncertainties around the approval of the plans, and that could be really, really quick, especially in those cases which we just discussed, are not backed by enough assets. So I think great suggestions have come on this panel. I think we are not left with too much time here. Abha, over to you for the conclusion of this session.
Thank you, Anup, and congratulations for catalyzing very engaging and in-depth discussions on the panel today. I also thank the panelists for sharing their views with us. I'm sure the audience would have found it very meaningful, and they will be definitely factored in as a roadmap is charted to further strengthen the regime. I like to thank the audience for staying with us this morning. And I can say that at FICCI, we'll be further deliberating on the issues that were raised today. And please feel free to write into us with your inputs. Thank you. Thank you so much.
Thank you. Thank you.
Thank you.
Thank you. Thank you, everyone. Thank you. Bye.
Thank you, Prakashji, Rajeshji. No.
Thank you. Thank you. Thank you.